I'm going to be talking about a decision that came down last December in the case of Inoue v. Kemna. And I am, as the introduction just said, Martin, and I'm author of this book, Recovery by Choice, a workbook that Lifering Press puts out. And I've got another book coming out by Josie Bass, Wiley & Sons, in April on recovery. So, and yesterday was 16 years clean and sober for me. Thank you. So let's plunge directly into the subject of Inoue v. Kemna. Ricky Inoue was a resident of Honolulu who was addicted to methamphetamine, a very serious addiction, and he was caught and arrested and sentenced, convicted and sentenced on a number of drug crimes, possession and related crimes. When he was released from prison, he became a client of Mark Nanamori, his parole officer. While he was already in prison, he made it known that he was a Buddhist. And Mark Nanamori, his probation officer, knew this. Also, while he was in prison, he filed an initial lawsuit, not the one that we're concerned with here today, but an earlier lawsuit against prison authorities on the grounds that sending him to the prison treatment program, which was AA or NA based, violated his religious beliefs as a Buddhist. That lawsuit eventually tapered out and went away, but Nanamori knew about it, so that it gave him notice that Ricky Inoue objected to being sent to AA-NA. Furthermore, when he was released from prison, Ricky's lawyer sent a letter to the probation department, which Nanamori saw, which you could barely read due to a resolution problem on the screen here. But it says, Mr. Inoue is a Buddhist. As such, he objects on grounds of the establishment and free exercise clauses of the First Amendment of the United States Constitution to any state-imposed religious practice as condition of his parole. Enclosed is a copy of the decision in Kerr versus Ferry. Remember that, it'll come back. Which holds that Alcoholics Anonymous 12-step programs cannot be imposed by the state as a requirement for eligibility for parole. Mr. Inoue doesn't object to participating in a substance abuse treatment program per se. However, he does object to any program that has an explicit religious content. This includes, but not limited to, prayers at meetings. Please assure that there's no religious content in whatever treatment program you send him to. This is a letter that Ricky's lawyer sent to the probation department. What happened? Nanamori sent Ricky for a parole violation to the Salvation Army. And as will be no surprise to anyone in this room, the Salvation Army is, of course, very religion-based and sends people to AA-NA. Ricky he tried. He said he attended a few sessions of the Salvation Army program, went to a few AA-NA meetings, but then he stopped going. And because he stopped going, Nanamori said, "You're in breach of your parole. You have broken the terms of your parole. Consequently, I am moving to send you back to prison." A hearing was held. The parole board agreed with Nanamori and sent Ricky back to prison for 6 months for refusing to attend AA-NA meetings. When Ricky got out, he filed a second lawsuit, and that's the one that we're concerned with, where he sued Nanamori, Nanamori's bosses, the county officials, and the officer who arrested him, Kemna, which is where we get to the name Inoue v. Kemna, for violating his constitutional rights. His suit was based on a law called 42 U.S.C. 1983, or 1983 for short. And 1983 says that if someone violates your constitutional rights, you can sue them for money damages. And basically what this law says is that if you violate somebody's constitutional rights, you have to pay. That you're damaging them just as if you injured them, broke their leg or something else. You're breaching their constitutional rights, and so they're entitled to damages from you. The specific constitutional right that Nanamori said was violated was the Establishment Clause of the First Amendment of the U.S. Constitution, which, of course, says, Congress shall make no law respecting an establishment of religion. That's the Establishment Clause. Or prohibiting the free exercise thereof. That's the Free Exercise Clause. But we're mostly concerned here with the Establishment Clause. The case was heard initially in the Federal District Court in Honolulu. And in that court, Nana Mori won and Ricky lost. But it's important for you to understand when you look at this lawsuit and the law that came out of it, is that in this initial case in federal court in Honolulu, the lower level federal court, Nana Mori agreed, and the other defendants in the lawsuit agreed, that the 12-step program is basically religious. Not a religion, but religious. They didn't argue. They said, yes, it may be. They also agreed that sending Ricky to a 12-step program against his will, coercing him to go there, would be a constitutional violation. So you have to understand that the way this case came down is there was no argument here that 12-step is religious and that sending somebody, coercing somebody to a religious program is a constitutional violation. So what was the fight all about? Well, Nana Mori claimed that at the time he did this, which was 2001, that the law of the United States was kind of fuzzy on this issue, that it wasn't settled. And so that as a probation officer, parole officer, he wasn't required to know that the law was solid. He was entitled to make a reasonable mistake about it because there were conflicting opinions. And this constitutes what's called the defense of qualified immunity. Now, don't get this mixed up with the so-called defense of ignorance of the law. There is no defense called ignorance of the law. You're required to know what the law is, but as an ordinary citizen. But if you're a government official, by some weird paradox of the law, if you're a government official, you're entitled to the defense of ignorance. As an ordinary citizen, you're not. But as a government official, you're entitled to a defense of confusion or unclarity or ignorance, and that's called qualified immunity. Don't ask me how that evolved. It sounds totally upside down. It should be that the ordinary citizen should have a defense of confusion, and the government official should be held to a higher standard of knowing what the heck the law is. But that's the way it is.
I say just ask President Bush.
There you go. So that was Nana Mori's defense. He said, yeah, they're religious programs, and yeah, sending him is a constitutional violation, but it wasn't clear to me that that was the law at that time, and my mistake was unreasonable under the circumstances. So, as I said, Nana Mori won, Ricky lost, but Ricky appealed the case to the next higher level in the federal system, and that's from the Federal District Court in Honolulu to the Ninth Circuit Court of Appeals, which is located in San Francisco. And at that court, on September 7, 2007, the court came down with a decision written by Judge Marcia Berzon, there's a picture of her, reversing the district court, overturning its decision, and saying for a unanimous three-judge panel, that in fact the law at the time, in 2001, at the time that Nana Mori did what he did, was clear and settled, and Nana Mori should have known that sending somebody to 12-step, to any religious program in violation of their beliefs was a constitutional violation. The official citation, if you keep track of that, is Inoue Rikemna, 504 F3rd 705, 9th Circuit 2007. And I have made a stack of the decisions available here on the table, and I think most of you have that, although it may be that those of you who came in late may be shortchanged, and we'll have to get it off the web, or write to me and I'll get you a copy of it, okay? Now let's take a closer look at the court's decision. This all I said by way of introduction. Let's take an actual look at the court's reasoning. Because Nana Mori admitted that reverence for a higher power is a substantial component of the AANA experience, the court spent very little time in this case reviewing whether that was true or not. whether AA, NA are religious or not. Because both sides agreed that it was. So there was very little point for the court in this case to rehash the issue. That was settled for purposes of this case. Now, a little bit later, we're going to look at earlier cases, Kerr versus Ferry, and the Warner case in New York, where the courts did look at that issue in considerable detail and thrash it out, and you get a chance to follow the court's reasoning on that issue. But that was not an issue in the Ninth Circuit case in Inoue versus Kemna, because both sides agreed it was religious. Furthermore, because Nanomori admitted that sending a parolee to a religious program in violation of his beliefs would be a constitutional violation, the court spent very little time reviewing the constitutional issues. It just very briefly ran through the three-part test that previous courts had used to determine whether sending somebody to a religious program constituted a constitutional violation. And the three-part test basically was, has the state, the government, acted in this case? Number two, was there coercion? And number three, was the object of the coercion religious rather than secular? And of course you know that secular means non-religious. Applying this test briefly, the court answered the first question without any difficulty. Has the state acted? Yes, Nanomori was a parole officer, an employee of the government, and therefore his action in his official capacity was the action of the government, and therefore, in constitutional lingo, he was a state actor. Number one, satisfied. Number two, was there coercion? Well, yes, there was. Ricky was told that he had to attend SA and NAAA, or his parole would be violated. And in fact, when he refused to attend, he was sent to jail. You don't get much more coercion than that unless you go to that prison in Baghdad. Abu Ghraib, yes. So points 1 and 2 were easily satisfied. Point 3 was the object of the coercion religious rather than secular? And there again, in this case, the court had very little difficulty because of the fact that both sides agreed that the AA-NA program is based in a higher power and is substantially based on religion. Again, it doesn't mean they're religions. It just means that it has a substantial religious component because it's based on a higher power and so on. And you get more detail on that in the later cases that I'll go into in a minute. A lot of earlier cases that I'll go into later. So, in sum, and this is text from these are quotations from the text of the decisions, Nanomori required Inoue to attend the program rooted in religious faith and then recommended revoking his parole because he refused to participate. For the government to coerce someone to participate in religious activities strikes at the core of the Establishment Clause of the First Amendment. Now, I don't think I need to review why the Establishment Clause was set up. It goes back into English history with the establishment of the Church of England as the state church, and so forth and so forth. You all know what used to be the longest word in the English language, anti-disestablishmentarianism. Okay, that has to do with the establishment of the Church of England as a state church. And the Founding Fathers did not want any state church. And so any action by the government that had the tendency to make church attendance required by the government is an establishment of religion, given that history of it. And so that's, in a thumbnail, the background of that particular clause that was violated in this case. To say it another way, as another quotation, a memorable quotation from the decision, while we in no way denigrate the fine work of AA-NA, which is later modified in a footnote to some extent, which we'll get to, attendance in their programs may not be coerced by the state. The Hobson's choice that Nanomori offered Inoue to be imprisoned or to renounce his own religious beliefs offends the core of Establishment Clause jurisdiction. Hobson's choice, I looked it up. Hobson was a horse renter in the Middle Ages, late Middle Ages, and he said, you can have the first horse, you can have the horse in the first stable next to the gate, or no horse at all. Hence, Hobson's choice. After disposing of these preliminaries, the court gets down to the real issue in this particular case, and that is whether the law on this point was so clear and settled in 2001, at the time that Nana Mori sent Ricky to jail, that a reasonable government official should have known that that was the law and should have known that he was breaching the law. And to that effect, the court reviews the prior decisions, which we'll do in a moment here, very briefly. And the court's conclusion is that the vastly overwhelming weight of authority on the precise question in this case held at the time of Nana Mori's action that coercing participation in programs of this kind is unconstitutional. And then it goes into a review of the prior cases. This is where you can see the law clerks and the research attorneys all working overtime to review all the prior cases on this issue, and the court then marshals them. And this is where we get a little bit more into the constitutional guts of the question of whether AA and NA are religious, and if so, why the court held that they are. The first case that the court goes to is Kerr v. Ferry, the one I mentioned earlier. Kerr was a prisoner, Ferry was a warden, and the holding of the case, the gist of it, was that requiring a state prisoner, this is in Wisconsin, to attend a substance abuse counseling program with an explicit religious content on pain of being rated a higher security risk and therefore being sent to a medium security instead of a light security prison, violates the Establishment Clause. And in this case, as I said, the court works on the issue to a considerable effect. The court heard arguments that said, the 12 steps aren't religious, they're spiritual. Your God can be anything you want, your higher power can be anything you want, can be a doorknob, can be the fellowship, or whatever. And the court says, we're not persuaded that this is not religious. The court says, a straightforward reading of the 12 steps shows clearly that they're based on the monotheistic idea of a single God or supreme being. And that's hard to disagree with, right? Because it does say God as you understand him. It doesn't say gods or her as you understand him. And it's true that God might be known as Allah to some, right? Yahweh to others, or the Holy Trinity to others, and many other things. But the 12 steps consistently refer to God as we understood him. And even if we expanded the steps to include polytheistic ideals or animistic philosophies, they're still fundamentally based on a religious concept of a higher power. Now, what did the court mean by that? Well, if you read the decision, the court explains what it means. In a 12-step group, if everyone has the right to pick their own higher power, person A might have one higher power, which, for the sake of logic, let's say is blue, and you'll have another higher power who is green, and your higher power might be red, and your higher power is yellow. And so we have a collection of different higher powers, not just one, but multiple higher powers. Now, each of those higher powers is a God, as you understand it. So, in the room, what we have is not a monotheistic religion, because you don't all believe in a yellow God, but a polytheistic religion, many gods. And so the 12-step universe can be understood as a polytheistic religious philosophy, a religious philosophy in which there are many possible gods, which each person having their own individually tailored God. You make up a God that you like, that works for you, so that's your God. The person next to you makes up an entirely different God, and that's their God. And so when you put it all together, what you have is polytheism, but that's still religion. Polytheism is a form of religion. I mean, you look at an encyclopedia of religion, and, there's monotheism, there's polytheism, they're all religions. And then you can go further and say, what does the court mean by animism, animistic philosophies? Well, that's to meet the argument that your God can be a light bulb or a doorknob. How many people have heard that?
Oh, yeah.
Everybody, okay. All right. That your argument can be, that your God can be a material thing. Well, that's also a very old religious idea. I mean, the Greeks believed, for example, that rocks had little gods in them, and that stones and that trees and clouds and every little thing had its own little god or a spirit inside of it. And many Native American people believe that plants have gods and every animal has its god and so forth. And that belief that supernatural forces reside in material objects is called animism. It's a religion of animism. And again, you can look up in the Encyclopedia of Religion. When the court is not off the wall here, it's just following standard theological analysis. Go to theology school, have a class on animism. That's what it is. Okay? So the court was not persuaded by arguments that your God could be anything you want it to be. The court said, well, it's still a God. There could be different kinds of theology involved, but it's still a God. It's still a branch or variety or flavor of religion. And then the last sentence, furthermore, Kerr the prisoner alleged that the meetings were permeated with explicit religious content. He's talking about the prayers. What is it, the Lord's Prayer at the beginning, and then the solidarity, the serenity, excuse me, yes. And then there is, almost at the same time, let me backtrack. Kerr versus Ferry came down in the 7th Circuit Court of Appeals. The 9th Circuit Court of Appeals is out here on the West Coast, covers 11 states, which I'll show you the map in a while. The 7th Circuit is based in Chicago. It covers 3 Midwestern states. And then, almost at the same time, a case came out in New York covering New York State, Vermont, and Connecticut. Warner versus Orange County Department of Probation. It grew out of a DUI, where the judge, at the recommendation of the probation officer, sentenced Warner to attend AA meetings, where Warner vehemently objected. He said, I'm an atheist, I don't want anything to do with this. Kerr, by the way, was not an atheist. He just believed in free choice. He said, my further religion is irrelevant, but I believe in free choice, I don't believe in powerlessness, and so on. But Warner was an atheist. And here, again, the court looked at the evidence of the meetings that Warner attended, and looked at the 12 steps, and heard the arguments that it's spiritual, not religious, and was not convinced, and said the program that Warner was required to attend involved a substantial religious component. Again, not that it's a religion, but that it has a substantial religious ingredient or component. For example, the 12 steps included instruction that participants should, quote, believe that a power greater than ourselves could restore us, that we make a decision to turn our will and our lives over to the care of God, as we understand Him, that we admit to God the exact nature of our wrongs, be entirely ready to have God remove all these defects, ask Him to remove our shortcomings, seek through prayer and meditation to improve our conscious contact with God, as we understand Him, and so forth, all of which, in the court's reading, was straight up religious. And also, as in Kerr, the court took note that these meetings generally began with prayer and ended with prayer. Group prayer was a common occurrence at the meetings Warner attended. They frequently began with the religious invocation and always ended with a Christian prayer. Hence, the AA meetings have a substantial religious component. These are phrases from the Warner decision. That they contained religious exercises, i.e. prayers. That they were religion-infused, saturated with religious concepts. That in some cases there were intensely religious events. And that AA itself was a long-term program of group therapy that repeatedly turned to religion as the basis of motivation. This was the court's finding. This appears in the Second Circuit Court of Appeal decision in Warner versus Orange County Department of Probation. And, which was critical to the decision, was that Warner was not given a choice. Neither the probation nor the sentence offered Warner any choice among therapy programs. All directly recommended AA without suggesting that he might have an option to select another therapy program free of religious content. That was the crux of the case. Now, in this case, the county probation department, which lost in Warner, appealed it to the Supreme Court, the next higher level. And the U.S. Supreme Court, which has the power to decide whether or not to hear an appeal, decided not to hear it. Now, what that means is that the Supreme Court left it alone. That isn't the same as affirming it and say, yes, we agree, but it also doesn't overturn it. It just basically says, we, the Supreme Court, are not going to mess with it. We're going to let it stand. That was in 1997. So there it stands. Now, stepping outside the law a little bit, you need to know that the Ninth Circuit Court of Appeal is considered a very, quote, liberal, unquote, court. But the Second Circuit in New York is considered a very moderate, pro-business kind of court. And the Seventh Circuit in Chicago is considered a very conservative, Republican, as it were, court. So what you have here is the Ninth Circuit following the Seventh Circuit and the Second Circuit, creating a kind of across-the-board, across-the-aisle, left-to-right consensus among the highest federal appellate courts that AANA are substantially religious and that coerced participation in AANA constitutes a constitutional violation. Not only that, but there were other cases in lower courts, not only these federal appellate cases, but other cases in lower courts which are listed here, all of which say essentially the same thing that I've just said from Kerr and Warner. And after 2001, so the court summarizing the prior cases says that this is a march of unanimity. The prior decisions as of 2001 constituted a march of unanimity. And that this continued after Nanamori's action, so that we have additional cases, 4 additional cases that came down between 2001 and 2007 that all say the same thing, that it's religious and that coercing them is a constitutional violation. And then after Inouye v. Kemna came down, based on my own research and the research of others, 2 other cases have come out saying the same thing. One of them from Michigan, which says that a drug court manager is liable for coercing a Catholic to attend a faith-based program run by Protestants. Now, this is not directly 12-step, but it's in the same area. And then a very interesting case from the 8th Circuit, which is a Midwestern, central Midwestern circuit, Americans United versus Prison Fellowship, which says that state funding of a faith-based prison program is unconstitutional. It violates the Free Exercise Clause and the Establishment Clause. Now that's, again, it's not quite the same thing as coercing someone in. What it says is that the government funding a faith-based program in a prison is a constitutional violation. A very important case because there are, unfortunately, many instances of the government funding faith-based programs. Bottom line, the court decided a reasonable person, a reasonable probation parole officer in Nanamori's position should have known that this was unconstitutional, and therefore Nanamori does not have the qualified immunity defense. Therefore, Nanamori loses. The case goes back to Hawaii for the court in Hawaii to decide how much, if anything, Nanamori has to pay Inouye. Ricky, by the way, died in the meantime while the appeal was pending, so his son is continuing the case, his son Zen. And I talked to the lawyer, Shetley, in Hawaii, who won this case, both in Hawaii and at the Ninth Circuit. And Shetley says that the case is set for trial in November this year, so just very briefly, very shortly from now. And that even if he wins just $1 in damages for Ricky, that his attorney fees are going to come to the high tens of thousands. So Nanamori and his agency are very likely to be on the hook for a significant sum of change for having sent Ricky to the Salvation Army without giving him a choice in the matter. Mind you, nobody can predict how lawsuits will come out. Who knows? Maybe the court will turn it around and we'll have further proceedings. But that's the way it stands right now. And no appeal to the Supreme Court in this case has been filed. So, at the present time, the states that are covered by this set of decisions that I've read you are the ones in green. And so you see the whole Ninth Circuit is all the western states, including Hawaii and Alaska. And then the Eighth Circuit is the states in between. And the Seventh Circuit is the states right around Chicago, there around the lake. And the Second Circuit is New York, Vermont, and Connecticut. And in addition, there were state court cases decided in Tennessee and Virginia to the same effect. So you have I haven't counted, in approximately 20 states, but please don't quote me on that exact number. In something like that, you have this being the law. Choice of support groups is the law. In other states, the issue just has not come up. It's come up I know it's come up in some states, but the cases were settled out. For example, I know it came up in Texas, but the cases were settled out before they came into a decision. The prison system decided this is a losing proposition, so the prison system settled the case out and went ahead and installed a secular alternative in the prison system years ago. And the same thing is true in some other states where they see the handwriting on the wall. They say, well, you know, we got to provide secular alternatives, or we got to get sued. These are the states covered by the decision to date. And now let's look at what it means, or it gets to your question, okay? What it means for the referral practice. First, a couple of things that it doesn't mean. It doesn't mean, for example, that the courts have said that AA or NA are a religion. I pointed to that a couple of times earlier. No, they don't say that they are a religion. They just said that there's so much religious content in it that for Establishment Clause purposes, referral is unconstitutional. We don't hold that it's a religion. We only hold that the AA program involved here has such substantial religious components that governmentally compelled participation violate the Establishment Clause. So the word is substantial religious component, okay? And that distinguishes from things like under God in the Pledge of Allegiance, or in God we trust on the penny, things where the religious things are incidental, minor, trivial. And I suppose if AA meetings only had a mention of God like that at the beginning of the meeting and no other religious content, people would say it's trivial, forget about it. But because it is, as we saw earlier, because it is throughout the 12 steps, and because on top of that the practice of Christian prayer, the court found that the religious component was substantial, even though they're not religions themselves. It also, the cases also, just a moment, the cases also do not mean that referral to AA or NA is forbidden. I know some people seem to have that idea from this decision, must have read it very shallowly. It doesn't mean that you can't refer clients or offer clients AA or NA. No. In fact, the court says, fine work that AA and NA do, although in a footnote, the fine work gets to be a pretty lukewarm endorsement. If you read the footnote 10, it says, quote, the confidential nature of AA-NA treatment makes testing efficacy difficult. There is, however, some data to suggest that the programs, as part of a larger treatment strategy, have helped many people maintain their sobriety, at least for a period of time. Okay? So that's an endorsement, but not a real gung-ho, Yahoo, 3 cheers, have a cigar kind of endorsement. You know what I'm saying? It's pretty qualified quite a ways. But bottom line is, there's nothing wrong with offering people AA or NA. What's wrong? And it also doesn't mean, one final point that I saw in another commentary, it doesn't mean that the client first has to write a letter or file a lawsuit before you, the probation officers, are required to know what the law is. In fact, the court says specifically, Nanamori should have known, because there's not one single case anywhere in the country that says it's okay to coerce people into a religious program. Nanamori should have known from that fact alone that what he was doing was a constitutional violation. But when he also got this letter that we saw earlier and knew that a lawsuit had been filed, all excuse evaporates. Justice for you who are here today, all excuse evaporates should the situation come up, because you've been here and you've heard this, okay? But what it does mean? Well, we saw a 3-part test earlier, and the first part of it, did the state act? Was a state actor involved? Well, Nanamori clearly was a state actor as a probation officer. So it applies to all state actors. Definitely criminal justice officials, right? Probation, parole, what else there is. If you have power, governmental power over the client, then you're a state actor. Almost definitely it applies to counselors at other government agencies. Prop 36, for example. I'm not sure exactly what the bureaucratic setup is in Prop 36, but because it is state mandated, it comes out of the criminal justice system, almost certainly the power and the people that hold the power in the Prop 36 referrals would be considered state actors. The state bar, which is an agency of the government, state government, is a state actor, no question about it. I don't know about the medical board, the BMQA, whether that's a state actor or not, but it's a fairly broad. There's a whole jurisprudence as to who constitutes a state actor, and it extends quite a ways out, and I don't want to get into the details of it, but if you are in some way connected with government action, even though you may not be on the government payroll, but you're doing the government's work, you could be held to be a state actor. Almost certainly that private programs that are state-funded, substantially state-funded, would be considered state actors. And almost certainly private programs that are 100% privately funded would be considered not state actors. So if you belong to, Betty Ford, and there's no, and your patient is paid by private insurance or out of pocket, and there's no government money involved, and I'm not sure whether there is in Betty Ford or not, but let's say there isn't, yeah, they can do anything they want. But you also have to understand that these private programs have very limited power of coercion. The private program can't send you to jail because you don't go to AANA. All right? So this private exception here is maybe not as powerful or meaningful as you might think it is. And then that's the next point that we get to, but that's really the heart of the issue. The heart of the issue is you must offer choice. 1 second, I'll get to it. We have a lot of time here, so we'll have a vigorous question period, I'm sure. The heart of the law is choice. When you have power over the client, you must offer choice. What is forbidden is coercion to go to a religious program. And again, the Hobson's choice, and that's no real choice at all, that Nanamori was offered to anyway, to go to jail or to renounce his own religious belief and adopt different religious beliefs, offends the core of the Constitution. So, in other cases, in the Warner case, for example, they say, neither the probation department nor the judge offered Warner any choice among treatment programs. Had Warner been offered a reasonable choice of therapy providers so that he wasn't compelled to enter a religious program, the case would be altogether different. It would be an altogether different case if the probation department had said, okay, Warner, you can go to AA or you can go to LifeRing, your choice. There would be no case at all. And in fact, in one of the cases that came up, in O'Connor versus California, somebody tried to bring a lawsuit because AANA was offered, but at the same time, rational recovery was offered, which doesn't exist anymore, but existed at the time, and the court found no case. A choice was offered between a religious and a non-religious alternative. No case, no constitutional violation was made out. Kerr, again, the problem in Kerr was the only choice available to Kerr was the AA program. So, choice is the core of this jurisprudence. Bottom line, if you're a state actor and you require clients to attend treatment or support groups, applies to treatment or support groups, you must offer not only 12-step but also secular alternatives, or the pants can be sued off of you. Okay? That's what the lesson that these cases teach. Now, but where are the secular support groups, I hear many people ask? Well, and the reality is that secular support groups are much newer than AANA. AA has been around since 1935, and a town has to be awfully small for there not to be an AA meeting in it. NA is much smaller, but the secular groups are much smaller still. Now, I have an interest in this because I'm CEO of LifeRing Secular Recovery, and we have 50 or something like that groups in Northern California, so that in most towns in Northern California, particularly in the Bay Area, you're going to have a secular option readily available, whether it's drug court or some other kind of court that compels you to attend treatment or support groups. You have it, we're available, we're there. And in fact, we get quite a number of, we get people walking in and say, the judge sentenced me to attend LifeRing. We go, oh no. But that's there. And there are other organizations. There's Smart Recovery, which has, I think, meetings down here. And there's Women for Sobriety, which is a non-religious organization also. There's Secular Organizations for Sobriety, which I believe has some meetings somewhere here in the Southland. And there are others, although these are the main ones. So the first thing that you should probably do, if this is of interest to you, if this is a real situation for you, is to get on the web and look for secular recovery, or just secular addiction recovery, or alternatives. And you'll come up with these groups. LifeRing right away will come up at the top of your Google list. and the other ones as well. But if you don't have a secular group, one second, if you don't have a secular group, you can organize one. And I've talked to people this morning at the Life Ring table in the exhibit hall, in the atrium, when I asked them, well, what do you do when you get a client who doesn't like 12-step? And several people told me, well, we organize our own groups. We do something, just a general kind of support group or a process group that works. Okay, and that may work. Maybe that's something you can do. Or you can, if you ask us, for example, we'll tell you, well, you need a convener, a meeting facilitator, you need a room, you need a format. We can show you how to set up a secular support group. We have a format. We have a whole book a handbook for meeting facilitators that explains the whole process, the whole philosophy behind it here in great detail. And for people who want to do it in a structured way, we have a Recovery by Choice workbook to help people build individualized, secular, abstinence-based recovery programs. So it's out there if you reach for it. And if it's not out there, you can build it, and they will come, so that you will not be in a constitutional violation. You can organize your own secular recovery groups or bring in the secular recovery groups that exist. Okay? Now, some final words on this, and then we'll have the question session, and we get to argue all these things. I know some people are chomping at the bit to argue with the courts. All right. Number one, choice is not only the law, choice is good therapeutic practice. I'll give you an example. When I got clean and sober, when I got into treatment, I went to the Kaiser program in Oakland, Kaiser Chemical Dependency Recovery Program, and my case manager, at the end of the introductory session, the orientation, the assessment, held up for me 2 sets of schedules of meetings. He said, you've got to go to support groups. Here, the AA schedule, and here is the secular group schedule. Your choice. Go to whichever ones you want. Either one or the other, or mix and match. One from column A from 2 from column B. Okay? And I said, okay. And I happened to choose the secular group. And because I chose it, I felt invested in it. And I've been going ever since. I've gone to well over 1,500 meetings. Like I say, I'm 16 years clean and sober, doing entirely that. I've never been to an AA meeting, never done a step, never had a sponsor, and so forth. And I had a wonderful recovery. In part because I chose that path. And I think, check me if I'm wrong, that a person who is forced to go to AA versus a person who has a choice and chooses to go to AA, psychology says that the person who chooses to go AA is going to succeed better than the person who's forced to go to AA. Now, some people may argue with that, but the research on motivation, which I'm citing here from Hester and Miller's Handbook of Alcoholism Treatment Approaches, says a strong and repeated finding of motivation studies is that people do better at programs when they have chosen them, or when they perceive that they have chosen them. And that's true, by the way, also in blood banks. There's a wonderful story about the recent history of blood banks, when the blood banks were hit by the HIV crisis, so suddenly the available sources of blood donors narrowed down because, right away they've become very paranoid about men blood donors. And also the need for blood transfusions really stepped up. And so they hired consultants. Says, what can we do to bring more blood donors into the blood bank and have them come back? Because they found a lot of people when donating blood, they would pass out or almost pass out, and they would get sick to their stomachs and throw up. And the experience would be emotionally very painful, so they'd never come back. The consultants looked at this and studied it and said, okay, we have a solution for you. 2 magic words that would transform and did transform in their tests the nature of the blood donation experience. Those magic words are not, thank you,